Wait lang, matagal. Ayan. Sige. So now we're going to focus on the vendor. So what are the obligations of the vendor? Before we went or we start with this chapter, we've already discussed on the first ever article of the contract of sale, di ba? Now we have defined the sale, and we can see from that definition already the obligations of the vendor, di ba? Under Article 1495, the vendor is bound to transfer the ownership of and deliver. So this one, these two obligations right here, we can already see from the first article nung chapter 1. So this is found already in chapter 1. Diba? So these obligations are not new. So alam na natin ito. The vendor is bound to transfer the ownership of and deliver. Okay? But here under Article 1495, na-introduce tayo to another obligation of the vendor, which is to warrant the thing, which is the object of the sale. Now, there is a specific chapter on warranties under this subject, but i-discuss lang natin in advance konti. Okay, so we're going to talk about warranties fully kapag dating natin sa chapter proper niya. Okay, so what are the principal obligations then of a vendor? The first one is to transfer ownership of the determinate thing sold. This one we have already discussed during our previous discussions. Diba? It is not the sale that transfers the ownership of a thing na binenta mo. Diba? What operates to transfer the ownership of the thing? Diba? It's not the sale, because as we have discussed, sale is merely a title. Okay? It is the delivery, okay, that operates the transfer of the ownership, di ba? We have discussed before that under the civil code, okay, wala doon, hindi mo makita doon ang sale. Okay, we can only transfer or we can acquire ownership or transfer ownership by tradition, di ba, which is to deliver the thing. Bakit tradition? Kasi before merong anything that's put into writing, before merong rules, before merong law, okay, the practice was when you sell something, you deliver it. Okay, that kaya sabi niya, by tradition. Okay, that's how we transfer ownership. Okay, so by transferring ownership, we are fulfilling two obligations of the vendor. Una, of course, transfer and to deliver the thing. Okay. The third obligation of the vendor is to warrant against eviction. Okay. Warrant against eviction, dalawa yan. Dalawang warranties. Pero under the chapter warranties, madaming wino-warrant si seller. Okay. Warranties against eviction and hidden defects. Of course, ito general kasi. Later on, I will discuss that specifically, okay? To warrant against eviction, okay? For easier understanding, okay? Kapag nagbenta ka, you're guaranteeing to your buyer or to your supposed to be buyer na that property is yours, okay? Hindi yan pagmamay-ari ng iba. Pagmamay-ari ko yan. Okay? For example, in a sale of land. Okay, in a sale of land. Okay? The seller warrants against eviction. Meaning, the seller will guarantee to you na that land belongs to the seller and that the buyer will not be evicted. Attorney, anong eviction? Anong evicted? Hindi ka ma-oust of your what? Of your ownership. Hindi ka mawawalan ng ownership. Okay? Because realistically speaking, okay, when we talk about sales of real property or sales of land under practice of law, okay, most of the cases yung mga ganito. Okay, may mga binibentang lupa and then later on, after ilang years or ilang months, merong nagko-contest na sinasabi na ako ang may-ari ng lupa. Okay, hindi si seller. Merong ibang party na nagko-contest. E nabili mo na buyer. Later on, kinasuhan ka nitong party. Okay, because of that case, natalo ka, you are evicted. Yun ang ginagaranti ni seller na hindi ka may evict sa ownership mo dun sa lupa. Okay? Okay. So, I hope that's clear. Okay, warranty against eviction. Warranty against hidden defects, of course, na what you sell, kumbaga what you sell, or what you introduce to sell is what you will really sell. Kumbaga wala siyang hidden defects. Okay, meron kasi, like let's say for example, in a real case, pagbibenta ng sasakyan, okay, usually yan, kung second hand yan, kaya meron tayong, kapag second hand yung sasakyan na yan, meron ng, of course, normally meron ng warning yan sa kahit sinong buyer na yung sasakyan na yan, hindi na yan 100% na okay. Kasi nga, second hand na yan. It may have may mga gas-gas, meron ng mga defects. Okay, that must be disclosed. Yung iba kasi dyan, pinapaayos. Okay, after a week lang na nabili mo, saka lang lumalabas yung mga defects niya. Or after 2 weeks, saka lang lumalabas yung mga defects niya. Kasi kapag binibenta yan, pinapaayos yan, pinapakondisyon yan. Okay, para kapag nabenta, okay, after 2 weeks, or after ilang days, lalabas na yung mga sakit niya. Okay. But that's what a seller warrants. Okay. But in the case of that second hand, yung pagbenta ng second hand na sasakyan, okay, meron ng warning dyan sa buyer na hindi mo i-expect na parang brand new yan because it's already second hand. Okay. There should be that warning against you. That's why one of the obligations of a buyer or a vendee na rin is to, of course, inspect mo, investigate mo yung mga bibilhin mo, di ba? Hindi naman pwede hindi naman pwede nakarely ka lang kay vendor, di ba? Gaya nitong sa lupa. One of the obligations of a vendee is to inspect the lot. Di ba? Tignan mo yung lupa mismo. Okay? Mamaya, pinakita niya sa iyo yung title or yung titulo. Pagpunta mo sa mismong location ng lupa, may mga tenants pala, may mga nakatira pala na hindi nila kilala yung may-ari ng lupa. O, di ba? Ibig sabihin, red flag na yun. Mag-conduct ka pa ng other background na inquiries kasi mamaya disputed yung lupa na yan, binili mo, magkasakit ka sa ulo, di ba? Ayaw mo niyan, ganyan. Okay? So, that's why hindi lang si vendor ang may obligation, pati rin si vendee. Okay? Kaya mag-ingat kayo sa mga cellphone na binibili nyo. Okay? Lalo na kung nakaw yung cellphone na yan. Okay? Kasi meron tayong tinatawag na anti-fencing law. Ano yung anti-fencing law, attorney? Bawal kang lumampas sa fence. No. Ang anti-fencing law, pinipenalize niya yung mga buyers na alam nila na buyers and sellers, of course, ng nakaw na properties na alam nila na yung property na yun is stolen. You can read more about anti-fencing law. Okay, but that's not our focus. I'm just relating that to you. Mag-ingat lang kayo. Okay, kung alam niyo na nakaw yan or possibly na nakaw yung cellphone na yan, mas maganda hindi niyo bilhin. Okay? Walang buyer in good faith yan kasi makikita mo naman kung nakaw yung cellphone or hindi. Okay? To take care of the thing, the fourth obligation of the vendor is to take care of the thing, alagaan. Pending delivery with proper diligence. This one, the legal basis of this one is under your previous subject obligations and contracts. Diba? To take care of the thing pending delivery with the proper diligence or with the diligence of a good father of a family. Diba? Hindi ibig sabihin na the contract is perfected, na hindi mo na alagaan yung binenta mo. Okay, let's say for example, nabenta nyo today, i-deliver mo sa Saturday. So today is Thursday, bibenta mo sa Saturday. Hindi ibig sabihin na sa Friday or sa Saturday na hindi mo na siya aalagaan. Of course, you are required to take care of the thing with the diligence of a good father of a family. Okay, kung kailangan, kung madumi na or nadumihan, of course naman, konting punas or condition ng makina, okay, wag yung hahayaan mo na lang. Okay, kasi nga, hindi, nabenta ko na yan, okay na yan. Eh kung nabasag yung salamin or nagasgasan, di ba? That could be a reason bakit hindi na itutuloy yan ng buyer later on. So, you have to take care of the thing even though the sale has already been perfected. Basta, hindi pa na-deliver. Kasi nga, delivery transfers the ownership of the thing, di ba? Kung pending delivery, ikaw pa rin na seller ang may-ari, you have to take care of it. Okay? What happens when the seller fails to deliver at the stipulated period? And such period is of the essence of the contract. Of course, the seller has no right to demand the payment of the price. Kaya nga nung sabi ko kanina, under this question na lang, okay, the seller fails to deliver at a stipulated period, and such period is of the essence of the contract, meaning the period is one of the considerations why the contract is entered into by the buyer and the seller fails to deliver. Ibig sabihin, para lang yan, reciprocal and mutual obligation between the buyer and the seller. Okay? The seller cannot demand the price, okay, the payment of the price, if he cannot deliver the thing, di ba? Kaya nga reciprocal or mutual yung obligation nyo. Bakit mo sisingilin si buyer if in the first place you failed to deliver the property or the thing which is the object of the contract? Okay, you cannot force the buyer to do that unless the seller has delivered the property or the thing, then he can demand for the price, for the payment of the price. Pero kung hindi, he cannot. Okay? What is the effect of non-delivery? If hindi mo na-deliver, the buyer may ask for resolution or rescission of the contract. Papa-cancel yung contract. Okay? Of course, kailangan na magbabayad si buyer in the first place. So, i-cancel ko na lang. Or, hindi na natin ituloy yung contract. Okay, tandaan nyo lang, under Article 1495, the obligations of the vendor. Okay? transfer, deliver, warrant the thing. Okay, under obligations and contracts, to take care with the diligence of a good father of a family. And the last one, hindi ko pa na-discuss pala, to pay for the expenses for the execution and registration of the deed of sale unless there is a stipulation to the contrary. Under number 5, we have rules. Okay, the general rule, okay, si buyer ang si vendor. Si seller ang magbayad ng expenses for execution and registration of the deed of sale except if there is a stipulation to the contrary. Okay? But, okay, as an example, in real life scenarios, okay, and we're gonna talk about sale of a piece of land. Okay? Sale of a piece of land kasi dapat yan in a public instrument. In the first place, dapat yan in a public instrument. Is a deed of sale a public instrument? Yes or no? Hindi mo pwedeng sabihin, it depends. Okay, you have to qualify. Diba? Huwag mong sabihin, it depends, attorney. Hindi, huwag ganun ang sagot. So, you answer it this way. Okay? A deed of sale is a public instrument if it is duly notarized. Diba? I don't know if I have discussed this one to you. Okay? But having the deed of sale notarized, notaryo ng abogado, okay? Anong ibig sabihin ng notaryo ng abogado, attorney? In a more layman's term, you executed that deed of sale under oath. Okay, ibig sabihin, ginawa nyo yung deed of sale na yan under oath or na may panunumpa na lahat ng nakalagay dyan sa deed of sale na yan, totoo. Inagaranti nyo na totoo yan, ikaw ang may-ari niyan, na ganito, ganyan, na binibenta mo kay buyer, ganito, ganyan. Yan yung nakalagay sa deed of sale. Yan yung ninonotaryo. Sinasabi nyo na sa inyo yan, binibenta nyo yan under oath. Bakit under oath, attorney? Para kapag hindi totoo na ikaw ang may-ari dyan, pwede kang kasuhan. Okay? Kapag nagbigay ka ng statement under oath na hindi totoo, that is a perjured statement. You may be liable for perjury. Okay? Kaya hindi biro ang gumawa ng deed of sale, hindi biro ang magnotaryo ng deed of sale because you may be liable for perjury. Okay? Kasi nangangako ka na ikaw ang may-ari niyan. Hindi pala ikaw. Pwede kang makasuhan. Okay? Yun yung sinasabi natin na duly notarized. Okay? Kapag ka-execute mo nitong deed of sale, okay? So una, wala na tayong space. Una, mag-notaryo ka ng deed of sale. This must be notarized. Okay? This is a real-life scenario in the sale of a piece of land. Panotaryo ka ng deed of sale. Kapag panotaryo ka ng deed of sale, within 30 days under the BIR rules or memorandum, and within 30 days, dapat mabayaran mo yung capital gains tax niya saan? Sa BIR. Actually, dalawa yan. Kung ang business mo is magbenta ng lupa, ibang tax na babayaran mo. Pero kung nagbebenta ka ng lupa kasi kailangan mo ng pera, ayan, capital gains tax, mga one-time transactions. Capital gains tax ang babayaran mo. Okay? Take note, yung deed of sale na pinanotaryo mo, may date yan. Within 30 days, kailangan mabayaran mo yung capital gains tax sa BIR. Okay? Bakit? Kasi sa BIR, kukuha ka ng Certificate of Authority to Register. Or yung CAR na tinatawag. Or yung bagong tawag nila dyan, e-CAR. Ewan ko kung ano yung E. Pero e-CAR ang tawag nila dyan. Pero that's the essence of yan ang ibibigay sa iyo ng BIR. Kapag nailakad mo lahat ng papeles, pagpunta mo sa BIR, dala mo yung notarized na deed of sale, at saka yung ibang requirements na kailangan ni BIR. Okay? Pag nabigay mo lahat yung kay BIR, bibigyan ka na i-issuean ka ng Certificate to Authority to Register. Aanhin mo tong Certificate of Authority to Register. Ibibigay mo ngayon yan sa number 3, which is sa Registry of Deeds. Sa ROD. Bibigay mo sa ROD. Okay? Kapag bigay mo sa ROD, okay, after how many days or weeks, i-issuehan ka na ng bagong title. Okay? Kasi nga, yung title na hawak mo is nakapangalan pa sa seller. Okay? Pinaprocess yan. Pagdating mo sa ROD, iso-surrender mo yung title na yan. After ilang days or weeks, i-issuehan ka na ng title na sa pangalan mo na. Okay? Ganyan ang real-life scenario ng under a deed of sale. Okay? Yan, wala sa batas. Okay? Nasa practice yan. Ganyan. Okay? Yang number 1, number 2, number 3. Okay? Magkakaibang agency kasi ang involved dyan. Kaya wala yan sa general law. Okay? Nasa iba-ibang circulars or rules ng BIR, ng ROD yan. Pero ganyan pagkuha ng title. I'm just relating it to you. Ang nagbabayad ng expenses ng lahat ng yan, sinasabi natin is si seller. Okay? Under the law. That's the general rule. Pero in reality, si buyer usually ang nagbabayad. Nasa exception tayo in reality. Why? Kasi si buyer gusto niyang ma-process ka agad at malipat ka agad yung title sa kanya. Kasi kung si seller pa yan, siyempre, yung kita ni seller sa pagbenta sa'yo ng lupa, alangan ipambabayad niya dyan. Diba? Kaya ang ginagawa nila, okay, pag nabayaran na si seller, si buyer na ang naglalakad. Okay? Si buyer na rin ang nagbabayad ng lahat ng expenses. Okay? Kaya yun, ganun ang real life scenario. It operates on the exception, more on the exception. Pwede ba yun, attorney? Yes, pwede yun kasi meron siyang exception unless can always operate on an exception. Okay? Delivery, as defined, is the concurrent transfer of two things. What do you transfer? Of course, when you deliver, di ba? Kung nag-deliver ka, possession sa Shopee, sa Lazada, dineliver sa inyo, paghawak mo nung thing, that is under your possession, di ba? Possession under the law is when you have control, di ba? Control of the thing. Hawak mo. Possession, possess. Okay? Or on-end ownership. Of course, delivery transfers ownership. This one is provided by law. Okay? Actual delivery. Okay, actual delivery is when the thing sold is placed under the control as what I've said and possession of the buyer or the vendee. Take note, there are other kinds of delivery which we will discuss later. Okay? How about in an execution sale? Does the seller or the judgment debtor need to deliver the property under an execution sale? No. He is not required to deliver the property. So this, itong topic na to is an exception to what we have here, which is the vendor is bound to transfer the ownership of and deliver. In the first place, he is not a vendor, he is a judgment debtor. Diba? Execution sale, kapag hindi ka nakabayad ng utang mo, inattach yung property mo, binenta para masatisfy yung utang mo, ayan, judgment debtor ka. Okay, pagbenta ng property mo, ang tawag sa judgment debtor, you are not required to deliver the property sold. Why? Because you have the right to redeem the property within 1 year. Ibig sabihin, pwede mo pang bilhin yung property na yan. Kaya you're not obliged to deliver it immediately or right away. Diba? In the meantime, the buyer should not take actual physical possession of the property. The period of redemption or the period to redeem the property, which is 1 year, shall commence from the day the sale was registered in the ROD. Okay? Kapag na-annotate na siya sa ROD, then that's the time that you can, then that's the time that the period to redeem will commence. Kung hindi pa siya na-register, the period to redeem will not commence. Okay? Article 1496. The ownership of the things sold is acquired by the vendee from the moment it is delivered to him in any of the ways specified in Articles 1497 to 1501. So, we're going to talk about deliveries from 1497 to 1501. Okay, but under Article 1496 says here that the ownership of the things sold is acquired by the vendee from the moment it is delivered to him. Okay, bago tayo mag-proceed further, I'd like to remind you of the rule na sinabi natin noon na at the time of perfection of the contract, the seller need not be the owner of the property or need not have the right to transfer the property at the time of perfection. But, take note this is only a reminder. Na-discuss natin to before. But, at the time of delivery, the seller must be either the owner of the thing or must have the right to transfer the thing. Okay? So, this is in relation to Article 1496. Why? Because it is from the moment of delivery that the vendee will acquire ownership of the thing. Diba? It is from the moment of delivery that the buyer will acquire ownership. Then, therefore, if yan yung Article 1496, therefore, it must be that at the time of delivery, it must be that the seller has the right to transfer or is the owner of the thing. Para hindi kayo malito. Okay? Yan yung ownership. Ownership is acquired from the moment of delivery as what Article 1496 stated. Okay? Or in any other manner signifying an agreement that possession is transferred. That is 1497 to 1501, which we will discuss later. Okay? Except, okay? So, the general rule, ownership is acquired by the buyer from the moment it is delivered. That's the general rule. Ownership is acquired by the buyer from the moment it is delivered. Except when the seller and the buyer agree that ownership shall remain with the seller until full payment of the purchase price. Itong number 1 is a contract of sale. Okay? Pero the seller and the buyer agree na the ownership will not transfer until full payment of the purchase price. Okay? Number 2, or the second exception, contract to sell. Diba under contract to sell, the seller only promises to sell. It's not a contract of sale, di ba? Contract to sell is not a contract of sale. Okay? Ang contract to sell, the seller promises to sell the property upon full payment of the purchase price. Kapag nabayaran na yung purchase price, that's the time that the buyer and the seller will execute a contract of sale. Okay? That's one of the exceptions under the general rule that ownership is transferred from the moment the thing is delivered to the buyer. The third exception, sale on approval, trial, or satisfaction, from the word itself. Sale on approval, trial, or satisfaction, we will discuss this later. Okay? Ang ibig sabihin, the ownership will not transfer to the buyer upon sale. Magta-transfer lang ang ownership if the buyer accepts or approves of the property or the thing. Doon lang magta-transfer ang ownership. Okay, if it's a sale on approval, trial, or satisfaction. And last one, implied reservation of ownership. Paano implied reservation of ownership? Usually under equitable mortgages ito. Okay, which is discussed in a separate topic. But one example of this is implied reservation of ownership. Binenta mo nga, pero ikaw pa rin ang nakatira. Or, hindi mo pa rin naman dinadivest yung ownership mo dun sa binenta mo. Ikaw pa rin ang gumagamit, ikaw ang nag-i-enjoy dun sa thing. Okay, that's implied reservation of ownership. Ano yan? Ang pwedeng maging example niyan. Sale of a property with the right to repurchase. Ibig sabihin, binenta mo pero may right ka na bilhin ulit. Okay? Usually, ang period dyan within 1 year. Paano nangyayari yan? Okay? Binenta mo yung property pero bibilhin mo ulit. Okay? Usually, pwedeng instead na utang, ganyan ang ini-execute. Okay? Pero yung ownership or yung use or yung enjoyment ng thing nag-i-stay sa seller. Kasi nga, bibilhin niya ulit yung property niya. Okay? That's, ang tawag dyan, sale with the right to the purchase or pacto de retro sale. Pacto de retro sale. Okay, right to the purchase. Take note, payment of the purchase price is not essential to the transfer of ownership as long as the property sold has been delivered. Meaning, whether the price has been paid or not, okay, will not matter. It will not matter. What matters is there is delivery. When there is delivery, there is a transfer of ownership. That's the general rule, di ba? Yan yung sinasabi natin. Whether bayad or hindi will not matter. It's not essential. Okay? Basta ang kukonsider mo lang, may delivery ba? Kung may delivery, may transfer of ownership. General rule. Okay? And also, kung sino man yung may-ari ng pera does not also matter. Okay? Why? Because it's not the purchase price or the money that we consider whether the ownership is transferred. It is the delivery. Sabi ko nga, kung may delivery, may transfer ng ownership. General rule. Okay? Kasi nga, there are instances wherein the owner of the money is a different person. So, attorney, paano? When you enter into a loan, di ba? You enter into a mortgage, di ba? Hindi mo pera yung gagamitin mo para makabili ka ng sasakyan, ng lupa, di ba? That's the concept of it. Okay? Pero kapag dineliver na sa'yo, that's yours. That's your property. Under the law, di ba? Okay? So, we proceed to section 2 of the obligations of the vendor, which is delivery of the things sold. Ito na yung 1497 to yung sinabi na 1497 to 1501, delivery of the things sold. 1497, the things sold shall be understood as delivered when it's placed under the control and possession. Of course, nagiging repetitive na tayo. When it's placed under the control and possession of the vendor. This we have discussed earlier. Okay, we have also defined real or actual delivery earlier. Okay, but this one we have not discussed the kinds of delivery. So the first one is actual or real delivery, which we have discussed when the thing sold is under control and possession of the vendor. That's Article 1497. Okay. The second one is constructive delivery or legal delivery. Okay? Kapag sinabi natin constructive or legal delivery, walang actual delivery, wala kang dineliver. Hindi naman sa walang dineliver. Hindi mo dineliver yung property. Okay? Hindi mo dineliver talaga yung property. Constructive lang. Okay? Ang effect niya lang, actual delivery. Para lang siyang actual delivery. Pero, wala kang dineliver talaga. Hindi mo talaga dineliver yung binenta mo. Okay? The first under constructive delivery is by legal formalities. When we say by legal formalities, the sale is made through a public instrument. The sale is made through a public instrument. Ano itong mga binibenta na made through a public instrument. Okay? Ito yung lupa. Diba? Land. Lupa. Okay? Take note, I have discussed earlier. Okay? Public instrument, deed of sale ba yun, attorney? Diba? Don't answer, it depends. Diba? If the deed of sale is duly notarized, it is a public instrument. If it is not notarized, okay, it is a private instrument. What is the difference of a public and a private instrument? Private instrument, wala siyang presumption of genuineness and due execution ng document. Pero when we talk about a public instrument, okay, basta na notaryo kasi yan. Di ba yung sabi ko kanina, kapag na notaryo, it is executed under oath. Diba? Under oath yan. Ibig sabihin, its genuineness and due execution is presumed. Hindi mo kailangan i-prove. Ipakita mo lang na may notaryo, na may seal ng notary. Okay? Ang ibig sabihin niyan, it is genuine. Totoo yan. And duly executed. Totoo yan. Compared to a private instrument, nagpakita ka ng deed of sale na hindi na notaryo, walang seal ng abogado, ang question niyan, totoo ba yan? Baka gawa-gawa mo lang yan. Why? Kasi hindi na notaryo. Totoo ka bang siya pumirma yan? Okay, o baka ginaya lang yan. Di ba? Compared to a public instrument na in-execute yan under oath. Yan ang presumption niya. Yan ang difference ni private kay public instrument. Okay? Legal formalities. Hindi mo i-deliver yung lupa. Okay? I-execute nyo lang yung deed of sale. Okay? Sa notary public. Okay? Walang delivery ng lupa. Hindi mo naman ma-deliver yung lupa. Okay? Hindi mo naman ilagay sa truck. I-deliver mo yung lupa. Hindi ganun. Okay? It's made through a public instrument. Okay? The second one is symbolical tradition or traditio symbolica. Hindi mo i-deliver yung, let's say for example, yung car. Hindi mo i-deliver yung car. Ang i-deliver mo is yung key. Yun ang ibibigay mo sa may-ari. Ito yung susi. O, di ba? Kapag nasa kanya na yung susi, it means that the car has been constructively delivered to that person or to the buyer. Therefore, the ownership has been transferred. Therefore, si buyer na yung may-ari. Okay? Hindi mo, walang actual delivery na nangyari. Ang dineliver mo is yung key, which is considered as the symbol of the car. Therefore, that has been constructively delivered. It has the effect of an actual delivery. Okay? The third one is traditio longa. Okay? Takes place by mere consent or agreement. Ito yung tinatawag natin na by pointing. Di ba? Pagturo. Pointing. Say for example, you are negotiating inside or at the farm of the seller. Di ba? And gusto mong bumili ng either ng baka, ng baboy, ng kambing. Okay? Of course, hindi naman bubuhatin yan ni seller sa'yo at bibigay niya yan sa'yo. Of course, hindi. Okay? Kapag nag-agree na kayo, na yun, nakita mo ba yung baka na yun? Okay? Yung may tatak na P sa puwet. Yun yung benta ko sa'yo. Pag nag-agree ka, you consent, you agree, that is already a constructive delivery. Okay? By pointing. Or, sa cellphone na lang, di ba? Although, kapag cellphone kasi, actual delivery yun eh. No? Hindi lang siya consent. Consent yung perfection. Okay? Cellphone kasi, ibibigay mo lang. Napakadaling ibigay. Okay? Yan kasi yung sa pointing, pagturo-turo ng mga binibenta. Okay? The fourth one is traditio brevi manu. Meaning, the vendee, the buyer, has already the possession of the thing sold. So, binenta mo sa buyer, pero siya na ang may hawak nun. Okay? Take note just to clarify things. Ownership and possession are two different things. Okay? Just to clarify things. Ownership and possession are two different things. You can be the owner. Okay? You can be the owner of a property, but you may not currently possess the property. Pwedeng ikaw yung may-ari, pero hindi mo naman hawak or wala sa iyo yung property. Example, pinarenta mo yung property. Pinalis mo, pinaupa mo, di ba? Kung meron kayong apartment, kung meron kayong boarding, di ba? Yung may-ari nun, hindi naman siya yung nakatira sa apartment na yun, doon sa studio type na yun, hindi naman siya yung nandun, di ba? Kayo na may possession, di ba? Yan, yung example niyan. Or, you may not be the owner, but you may possess the thing, di ba? Yan yun, in the form of renting, di ba? Dito kasi, you are like the lessee, di ba? Lessee or the trustee. Dito, you are the lessor or the trustor. Diba? Lessor yung pinalis, upa. Trustee, trustor yung in a form of a trust agreement. Okay? Pinagkatiwala sa'yo. Okay? So, para ma-clear kayo, ownership and possession are two different things. So, balik tayo. Traditio brevi manu, the buyer has already the possession of the thing sold. Ibig sabihin, bago nabili ni buyer, siya na yung may hawak dun sa thing. Okay? By virtue of another title, like a lease contract. Example, okay? Si buyer, siya yung current lessee ng lupa ni seller. Siya yung nag-uupa dun sa lupa ni seller. Ngayon, bibilhin na ito ni buyer. Okay? Pag nabili na yan ni buyer, mag-change yung title niya from lease or as a lessee to owner or ownership. The fact na nag-iba yung character na yan, that is traditio brevi manu. Walang delivery na nangyari. Okay? Nag-iba lang yung concept or yung character niya. Si buyer dating lessee, since binili niya na yung property, okay, naging owner na siya. Okay? Ang pinopoint lang natin diyan, the buyer has already the possession of the thing bago pa niya binili. That is traditio brevi manu. Traditio constitutum possessorium naman, that is the opposite of the traditio brevi manu. Okay? It takes place when the vendor naman, the seller, continues in possession of the property sold, not as an owner but in some other capacity. We can use the lease example again. Okay? Si seller, siya yung may-ari, siya yung owner. Okay? Binenta niya kay buyer. Okay? Kay buyer. Yung property. Kapag binenta niya kay buyer yung property, hindi na siya nag-execute sila ng public instrument. Let's say for example, lupa, the buyer becomes the owner kapag one of the agreements or later agreements is si seller muna yung mag-occupy ng property by virtue of a lease agreement. So, from owner, naging lessee siya. Okay? So, from may-ari, inuupahan niya na lang. That is traditio constitutum possessorium. The opposite of traditio brevi manu. Okay? I hope you understand that one. Number 3, by quasi-tradition. What do you mean by quasi-tradition? When we talk about rights, credits, or incorporeal property or intangible property, dito siya na-deliver. Number 1, by placing the title in the hands of a lawyer or in the hands of the owner. Diba? Or allowing the buyer to make use of the rights. Yan yung under intangible property. Ano yung mga intangible property? Stocks, bonds, yan, ganyan. Article 1498. When the sale is made, ito na. Actually, isa-isa na natin kanina. Okay? Itong 1498 talks about, the first sentence talks about delivery by legal formalities. When the sale is made through a public instrument, the execution thereof shall be equivalent to delivery of the thing. The execution thereof shall be equivalent to the thing which is the object of the contract. If from the deed, the contract does not appear, cannot be claimed. This one is what we call a constructive delivery by or sale by legal formalities. Okay? We have discussed this earlier. Actually, na-discuss ko na pati yung public instrument, private instrument. The second sentence talks about symbolical or tradition symbolica or symbolical tradition. Okay? With regards to movable property, its delivery may also be made by delivery of the keys of the place or depository where it is stored or kept. Okay? Hindi keys na keys. Keys na susi. Okay? Yan yung symbolical delivery. Okay? Under this, there are 3 things that is required before ownership may be transmitted. Of course, number 1, the seller must have control over the thing. Di ba ang sabi ko nga, at the time of delivery, since walang actual delivery dito, kasi constructive delivery to guys, ibig sabihin, at the time na mag-execute ka ng public instrument or at the time na ibigay mo yung keys, susi, okay, dapat si seller merong right to transfer the property or siya na yung may-ari ng property. Okay? Second, the buyer must be put under control. Of course, the buyer must have the control and possession of the thing. Okay? Third, there must be the intention to deliver the thing for purposes of ownership and not merely to allow an inspection. Okay, so take note of the three things that needs to transpire before ownership may be transmitted. Kasi pwede namang binigay mo lang yung susi kasi gusto niyang tignan yung lugar o yung kotse o yung sasakyan. Diba? Okay? Or yung lupa kung public instrument. Diba? Pwede namang nag-execute or hindi pa kayo nag-execute, dapat tignan mo na yung lupa. Okay? Hindi yung nag-execute na kayo ng deed of sale, tapos ang purpose mo lang is para inspect yung lupa. Hindi, mali. Okay? Note, okay, this one we have discussed. When the sale is made to a public instrument, this one is yung 1498. Okay? However, in order that this delivery may have the effect of tradition, it's essential that the vendor shall have had such control over the thing sold that could have been possible at the time of sale, its material delivery could have been made. Okay? The keyword is control and not merely possession of the land. Execution of a public instrument or document, we have discussed this actually extensively na kanina. Okay? Possession transferred to buyer by notarized deed of conveyance or by notarized deed of sale. Okay? Delivery is presumptive only, of course, because there is no actual delivery here. Diba? There is only an execution of a public instrument. Walang actual delivery. But if you executed the public instrument, it is presumed that there is delivery. Sale of a thing not subject to control of vendor. Okay, symbolic delivery by the execution of public instrument is equivalent to actual delivery only where the thing is subject to control of the vendor and there is no impediment that may prevent the passing of the property from the hands of the vendor to the vendee. Okay? Sale of a registered land, of course, must be in a public instrument through a notarized deed of sale or deed of conveyance. Possession of a part may be constructive possession of the whole, of course. Ganyan sa sale ng lupa. Okay? Kasi merong case. Sabi niya, he only occupied the portion of a land. He cannot occupy the whole land. Of course, no one can occupy the whole land, especially if hektarya lang yung lupa mo. What number 5 is saying that is possession of a part of a land. Kahit konti lang dyan yung, let's say for example, nakaapak ka sa lupa mo yan, nakaapak ka sa lupa mo. Okay? That is already possession of the whole. Kahit dito ka lang nakaapak. Okay? Kahit ito lang yung binahayan mo, kahit di mo pinupuntahan tong portion na to, okay? That is considered as possession of the whole. You don't need to possess the whole lot. Okay? You can do that actually by fencing the land, di ba? Diba? You are establishing the metes and bounds of the land. You can do that. Pero hindi naman na maapakan mo yung buong lupa para masabi mo na you have the possession of the whole lot. No. Possession of a part is possession of a whole when we talk about real property or land. Okay? Article 1499. The delivery of a movable property may likewise be made by mere consent or agreement of the contracting parties if the thing sold cannot be transferred to the possession of the vendee at the time of sale or the latter had already been in his possession. Article 1499 is what we call traditio longa manu, di ba? Yung by pointing or by consent or agreement. Di ba? This one I discussed earlier kanina. Article 1,500 or 1,500, there may also be a tradition constitutum possessorio, which is the opposite of a traditio brevi. Okay? Sabi nga dito, where a seller continues to occupy the land as tenant. Diba? Yung example natin kanina, itong, saan na yun? Traditio constitutum possessorium. Ito, from owner to lessee. Diba? From owner to tenant, owner to lessee, owner to trustee. Iba-ibang klase kasi ng contracts, hindi lang isang example. Okay? Yan yung tradition constitutum possessorium. We have discussed that. 1501, with respect to incorporeal property, ito na yung quasi-tradition. Okay, quasi-tradition. Provisions of the first paragraph of Article 1498 shall govern. Let's take a look at Article 1498. Provisions of the first paragraph. So, execution of a public instrument. Okay? So, kapag incorporeal property, ang una is execution of a public instrument. In any other case, kapag hindi applicable ang 1498, the placing of titles of ownership in the possession of the buyer or his lawyer, or the use by the vendee of his rights, yan, shall be understood as delivery. Okay, they shall be understood as delivery. This one we have discussed na rin. Okay, Article 1502, probably the last article before we end tonight. Okay, when goods are delivered to the buyer on sale or return. To give the buyer an option to return the goods instead of paying the price, the ownership passes to the buyer on delivery. The ownership passes to the buyer on delivery, but he may revest the ownership in the seller by returning or rendering the goods or tendering the goods within the time fixed in the contract, if there's a time, or if there's no time, by within a reasonable time. Okay. First paragraph of Article 1502 talks about delivery of goods on sale or return. Take note, on sale or return. That's why I'm underlining the words or encircling the paragraphs for us to better understand the provision. Okay? Ang ibig sabihin niya, when the goods are delivered on sale or return, okay, the ownership passes to the buyer. Kapag on sale or return, the ownership passes to the buyer. Okay? Pero, kasi on sale or return yan, ibig sabihin, nabenta, deliver, na transmit yung ownership, or return, the buyer may return or yung term dyan, revest the ownership to the seller. How can he revest of the ownership? By either returning the goods or tendering the goods within the time fixed in the contract or within a reasonable time kung walang time fixed in the contract. Okay? Ibig sabihin, on sale or return at the will of the buyer. Okay? Kung ayaw niyang bilhin na totally yung property, he can return the property. Okay? And the ownership will revert or revest to the seller. Okay? How can you do that? By returning or tendering. Okay? Very simple naman. Return, ibalik mo. Tinanggap. In-accept. Tendering kasi, tinender mo. Ibig sabihin, in-offer mo na ibalik. Pero hindi tinanggap. Okay? Tendering ang tawag dyan. Say for example, in-offer mo na binalik yung binili mong cellphone sa seller pero hindi ka pinagbubuksan ng gate or ng pinto. Iniwan mo dun sa pinto or sa gate yung cellphone. That is tendering the goods. It means na I'm returning I'm returning the property, I will not pay the price, ito na yung property mo. So walang sale na nangyari. So, in other words, itong delivery on sale or return, either tanggapin ng buyer, okay, may sale, bayaran ko yung price. Or, hindi tanggapin ni buyer, ibalik niya, walang sale. Kaya ang tawag dyan, on sale or return. Okay, I hope that is clear. Second paragraph of Article 1502, when goods are delivered to the buyer, ito na, sabi natin kanina, on approval, on trial, or on satisfaction or other terms, the ownership passes to the buyer. The ownership passes to the buyer when he signifies his approval or acceptance to the seller or does any other act adopting transaction. Okay? Or if he does not signify his approval or acceptance, but retains the goods without giving notice of rejection, then within a fixed time or within a reasonable time, the ownership will pass to the buyer. Okay? So take note, just for you to understand Article 1502 better, magkaiba sila. There is a difference between on sale or return or sale on approval or on trial or on satisfaction. Under on sale or return or delivery on sale or return, sabi natin kanina, ownership passes to the buyer kaagad. Diba? May sale kaagad. Pero pwede kasing ibalik ni buyer. Yun yung on sale or return. Under sale on approval, trial, or satisfaction, okay, the ownership does not pass to the buyer upon delivery. Okay? Hindi magta-transfer ka agad yung ownership. Unlike sale, on sale or return. Okay? Why? Because of the term itself, on sale, on approval, or trial, or satisfaction. There must first be either an approval or acceptance on the part of the buyer. Kapag kinommunicate niya na yung approval or acceptance na yan, then the ownership will pass to the buyer. Okay, doon lang magta-transfer yung ownership. Or, hindi niya na communicate yung acceptance or approval. Pero, nasa kanya naman yung property. Okay? Nasa kanya yung property. Full bar ba? Nasa kanya yung property. Pero, hindi niya naman ni-reject yung hindi niya naman sinabi dun sa seller na ayoko ng property. Pero nasa kanya yung property. Okay? Within a reasonable time or if there is a time fixed in the contract, the ownership will pass to the buyer. Okay? That's sale on approval, on trial, or on satisfaction. Okay? Ayan. This one, I have discussed na lahat kanina. Diba? Sale on approval, walang transfer ng ownership kaagad. Kailangan muna ng approval or acceptance. Okay? Sale or return, merong transfer ng ownership. Diba? Upon delivery. The distinctions between sale on sale or return or sale on approval or trial or satisfaction. The first one, kapag on sale or return, it is subject to a resolutory condition. Okay. What is this resolutory condition? Okay. When the buyer opts to return or tender the goods to the seller. Di ba? Kasi on sale or return, ownership already passes to the buyer. Pero kung binalik niya or tinender niya yung goods, okay, ibabalik niya yung ownership sa seller. Okay? Resolutory condition. While sale on approval or on trial, subject to a suspensive condition. Meaning, kapag sale on trial or on approval, okay, it is subject to the approval, suspensive condition. Hindi pa matatransfer yung ownership kaagad kay buyer. Merong suspensive condition na whether i-accept or i-approve ni buyer. Okay? Or yung sa second na instance, hindi niya in-accept, hindi niya in-approve, pero nasa kanya pa rin, hindi niya din ni-reject. Okay? The ownership could transfer within reasonable time or within a time fixed in the contract. Sale or return depends entirely on the will of the buyer, as I've said earlier. Okay? Kasi meron ng sale, pero at the option of the buyer, he can return it. Okay? Will, walang conditions. Okay? As to quality, wala. Okay? Basta pag binalik ni buyer, hindi niya nabayaran yung price. Ganun lang naman yun. That's simple. While sale on trial depends on the character or quality of goods because the buyer will either accept or approve or reject the thing, di ba? Ganun lang naman yan. Kung hindi niya in-approve, ni-reject niya, ibig sabihin walang sale na nangyari. Because maybe the quality of the goods is different from what has been represented to him. Kung sabi, ang ganda-ganda nito, maganda, maayos. Pag-deliver ng property, hindi pala. So, it is dependent on the character, the quality of goods. Compared to sale or return, no will of the buyer. Depende kung anong gusto ni buyer na mangyari. Okay. Number 3, on sale or return. This one, discuss natin. Ownership of the goods passes to the buyer on delivery. Okay? Pero pwede niya ibalik kay seller. Pero, sale on trial or on approval or on satisfaction, the ownership remains in the seller until in-accept or in-approve ni buyer. Okay? That one we have already discussed. Number 4, on sale or return, the risk of loss or injury rests upon the buyer. While sale on trial or approval, the risk still remains with the seller. Itong number 4 connected sa number 3. How? Kung titignan mo lang ownership. Under sale on return, okay, the ownership passes to the buyer, di ba? Sabi natin kanina. Under sale on approval, trial, or satisfaction, the ownership remains with the seller. Okay. We have this principle under the law, under the civil code, of res perit domino, or whoever owns the thing, okay, bears the risk of loss. Whoever owns the thing bears the risk of loss. Kung sino ang owner, sa kanyang risk of loss. Therefore, under sale on return, ownership passes to the buyer. Therefore, it is the buyer who bears the risk of loss. Tama? O, tama. Therefore, on sale, on approval, or trial satisfaction, the ownership remains with the seller. Therefore, the seller has the risk of loss. That's simple. On the concept or on the principle that whoever is the owner bears the risk of loss. Of course, in common sense, kung ikaw may-ari, kapag nawala yan, loss mo, di ba? Kung hindi ikaw may-ari, pag nawala yan, hindi mo loss. Di ba? That's common sense. Okay? Article 15 auto uses the phrase on sale or return. If the contract uses instead the phrases for sale or return, take note to, yung on niya naging for. The intention may be to enter into a contract of agency. That's why it's very important to check the words always that we use. Excuse me. If it's if it pertains to a contract, review the contract. Di ba? If it pertains to an insurance policy or kahit ano napipirmahan mo, basahin mo. Okay? It's very important kasi one word lang, mag-iiba yung meaning ng contract. Kahit pa sabihin mo dyan, contract of sale, if ganyan yung terms for sale or return, that could be a contract of agency. Okay? Because what is controlling is not the title of the contract. Kahit anong ilagay mo sa title of the contract, what is controlling is the essence or the agreements in the contract. Yun ang controlling. Kaya be careful. Okay? Nagtataka kayo na share ang mga datas nyo, na share ang profile nyo, meron nang nakahack na account nyo because i-relate ko na lang din sa digital world, di ba? Kapag may mga naggagawa kayo ng account or may mga may pinapabasa sa inyo, di ba, na terms and conditions. Although hindi nyo pinirmahan, pero tinik nyo yung check, yung box, chinek nyo, and then tinik nyo pa yung I understood, I fully read, I fully read the terms and conditions. That means kung ano yung nakalagay dun, pwedeng gawin nasa app. Okay? Kaya madaming mga na-hack, madaming nakukuhanan ng information because check lang sila ng check, they don't read the terms and conditions. And honestly speaking, pati naman kami kasi syempre nakakatamad din. Basahin yung liliit na terms and conditions, ang haba pa. But, para lang maging secure kayo, you should read that. Okay? Kasi mamaya ang sabi dyan, we can share your information to other networks that we own, or we can share this to other agencies that is under our ownership. Ganun. So magtaka ka na, meron ka na palang profile dito sa mga sites na ito. Never mo namang ginawa yan. Okay? So that's a lesson. So, mere one word lang. Very big. Okay? So let's continue next meeting. Article 1503. Oh, meron pa pala. Some rules on sale, on approval, or some rules on sale on approval or trial. Okay? This one I have explained, risk of loss. Since sale on approval yan, ownership remains with the seller. Therefore, risk of loss is with the seller. Except, okay, may exception siya. The buyer is at fault. May kasalanan si buyer. Or, sabi ni buyer, oo, sale on approval sa iyong ownership. Pero kapag nawala, babayaran ko. Or, I will bear the loss. If he has expressly agreed. This is the exception. But the general rule is what I've said earlier. Okay? Buyer must give goods a trial except when it's evident that it cannot perform the work intended. Of course, di ba? Sale on approval nga or trial or substitution. You are going to check the quality or the character of the goods. Di ba? Except if kitang-kita naman, evident na hindi niya ma-perform yung work intended. Okay? Example, sasakyan, binili mo sasakyan. Tatatlo lang pala yung gulong. Hindi mo siya pwede ma-test drive. Hindi mo na siya kailangan i-test. Kasi tatlo lang yung gulong, di ba? It's evident that it cannot perform the work intended. Yun yung number 2. Number 3, period for buyer to signify acceptance commences to run only when all the parts essential for the operation of the object have been delivered. Di ba? Let's say for example, bumili ka on approval or trial or substitution ng isang bike, sabihin mo na bike. And itong bike na ito, it is delivered in parts sa'yo. Okay? Ang na-deliver pa lang sa'yo is yung manubela, yung sa brake, yung body, wala pa yung gulong. Okay? Hindi mo siya matetest kasi wala pa yung gulong. Okay? Saka lang magra-run yung period na i-test mo yun kapag na-deliver na lahat ng essential for its operation. Gaya ng gulong. Okay? Yan yung sinasabi ng number 3. The period to approve or to signify acceptance shall start only kapag na-receive mo na lahat ng essential parts para matest mo yung property or yung thing na binili mo. Paano kung sinabi niya na yung third person ang mag-a-approve or mag-test? Okay lang. Okay? Pero, caution, the third person must be in good faith. Okay? Pwede lang na third person yan. Okay? Of course, if refusal to accept is not justified, na of quality naman, maayos naman yung binenta, pwedeng magkaso si seller. Why? Because it's sale on approval or trial or substitution. Kaya ang titignan mo lang dyan whether proper ba yung goods na dineliver sa'yo, quality ba. Diba? Generally, the sale and delivery to a buyer who is an expert on the object purchase is not obviously a sale on approval, trial, or satisfaction. Diba? If binenta mo sa tao na expert siya dun sa field na yun, or alam niya na yung thing na yun, expert siya dun, that's not a sale on approval, trial, or satisfaction. That is a sale. Okay, but who is an expert depends on the circumstances and facts. Di ba naman pwedeng sabihin na expert siya kagad. Okay? So that is some rules on sale, on approval, or trial, or substitution. Next week, we're going to continue with Article 15.3. Okay? Questions?
Wala naman po, sir. Ay, meron po ata.
Okay naman ata. Sige. If you have no other questions, thank you for coming to class. Have a good night. And goodbye, everyone. Bye. Oh, question.
Attorney, may tanong po ako regarding sa chapter 2 po. Dun po sa relative incapacity. Opo.
Oh.
Hindi po kasi gaanong clear yung part na employee and property of the state. But tinanong ko pa si mama kasi nag-work pa siya dati sa DAR. Employee and property of state po.
Employee and property of state or
Opo,
public
attorney.
official or public of employee and property of the state. Yun ang gusto mong tanongin. Okay?
Opo.
Tinanong mo si mama mo na dating tuloy mo.
Dating employee pa ng DAR. Kaya sir, may klase ako. Ganun po. Sabi niya po is hindi daw po siya a maximum of 3 hectares lang daw po ang pwede niyang i-own na land po kasi public employee siya. So, kapag 6 hectares po yung binili niya, pwede niya lang pong ipangalan yung other 3 hectares dun sa kamag-anak, ganun po ba?
Iba na kasi yan. Under agrarian reform na kasi yan, Miss Salva.
Apo.
Under agrarian reform, that is covered by agrarian law. Okay? Ang agrarian law, okay, or the Comprehensive Agrarian Reform Act. Hindi agrarian law itong subject na to, pero I'll just share. This law is intended for those farm workers who don't have or who don't have their own land to till. Okay? That is enacted way before pa. Okay? That is made for farm workers na hindi nila lupa yung sinasaka nila, which is rampant pa rin sa atin. Okay? If you own, ayan, 5 hectares or 6 hectares, okay, there is a limit kasi dyan na you can retain. I don't know the specifics kung ilan yung pwedeng i-retain. But that is not covered by our topic. Okay? Yung topic natin is sale. Tandaan mo, sale yung topic natin. Okay? Sale by a public, or binili ni public official or ni public employee yung property ni state. Okay? Kung sa agrarian reform or sa agrarian law naman kasi, okay, the property is owned by the farmer or by the owner. Malaking lupa niya. Farmer siya. Madami siyang farm workers. Okay? Itong farm workers na to, tenants lang niya. Hindi nila lupa yung sinasaka nila. Totoo yan hanggang ngayon, nakikita nyo pa yan. Diba? Madaming mga farm workers. Ibang farmer sa farm workers. Madami ang farm workers na nagsasaka sila sa hindi nila lupa. Madami yan hanggang ngayon. Okay? Ang may-ari ng lupa na yan is private, tao. Tao, hindi state. Okay? That's clear, Ms. Salva?
Opo,
Kaya
attorney.
sabi mo, si mama mo yung may-ari. Diba? Si mama mo yung may-ari. Hindi siya state. Hindi siya si government.
I mean po, bibili po siya.
Bibili siya.
Opo.
Under agrarian law, tignan mo kung pwede na bibili siya. Okay? Kasi employee naman siya ng DAR dati. Alam niya yan. Okay? Kung pwede yan gagawin niya or hindi. Okay? Pero yung tinutukoy ko, relative to our subject, yung subject kasi natin, hindi pwedeng bilhin. Explain ko sa iyo para ulitin natin. Hindi pwedeng bilhin or basta-basta bilhin ni public official or ni public employee ang property ng government or let's say for example, si mama mo, DAR, taga-DAR. Lahat ng property ng DAR. Okay? Kapag property ng DAR, hindi yung lupa. Okay? Hindi yung lupa. DAR lang, DAR sila. So, pwedeng sasakyan ng DAR. Okay? Lupa ng DAR na binili nila or na acquire nila. Pero hindi yung sinasaka. Hindi yun, iba yun. Okay? Hindi yun pwedeng bilhin ng nagtatrabaho sa DAR. Because that could imply that merong graft and corruption. Bakit nabili siya? Nabili niya kasi employee siya ng DAR. Diba? Pero yung sinasabi mo na operating under the agrarian law or by operating under the Comprehensive Agrarian Reform Act. Okay? Iba yun. Kasi ang may-ari ng mga lupa na covered ng Agrarian Reform Law is tao, private na tao, hindi gobyerno. Okay? Tao sila, madami silang lupa or malawak ang lupa nila. Okay? And madami tayong magsasaka na hindi nila lupa yung sinasaka nila. Ang ginawa ang function ni DAR mag-allocate yung may-ari ng lupa na yun ng portion para sa mga farm workers. Para mayroon naman silang, alam mo yun, para yung sinasaka nila sa kanila. Yun yung agrarian. Napaturo tuloy tayo ng agrarian reform. Ay lang, Comprehensive Agrarian Reform Act or Comprehensive Agrarian Reform Law. Okay? I hope na clear yan. Okay? Whether pwedeng bilhin yan ni mama mo or hindi, alam niya naman yan kasi sa DAR siya nagtatrabaho, sabi mo. There are requisites or requirements that she needs to comply kung ano man yung kailangan niya i-comply. Okay? But relative to our subject, iba yung nirelate mo kanina. Okay? I hope clear. Miss Alva.
Opo, attorney. Thank you po. May tanong pa po ako.
Oh, sige.
Yung dun pa sa guardian, agent, executors, and administrators, iba hindi pa nila pwedeng bilhin kasi baka may advantage or influence. What if yung spouse po nila yung bumili? Then, what if binili po nila pero nakapangalan sa close friend nila or kamag-anak? Ganun po.
Hindi naman sila yung bumili. Di ba?
So, legal pa rin din po yun.
Unless magkakaso. Di ba? Alam mo yan. Alam mo yan. Lagi kong sinasabi sa mga clients na you should always settle or wag kayong, kung pwede, wag niyong paabutin sa mga kaso. Kasi nga, kapag magkaso kayo, kukuha ka ng abogado, bayad, sakit sa ulo, yung trial, yung hearing, na schedule ngayon, pumunta ka sa korte, nag-leave ka sa trabaho, wala kang bayad. Okay? Pagdating mo sa korte, sabi nung kabilang abogado, pwede bang i-postpone, pinospone? Sakit sa ulo. Kung pwede kayong mag-usap or magkasundo, kasi panalo kayong dalawa kung hindi kayo magkaso. Okay? Kung ganyan naman, nagkakaso lang naman dyan kasi baka inabuso ni guardian. Kung wala naman, okay lang. Or, actually, pwedeng bilhin ni guardian. Paano? Kung of age na si minor, binenta sa kanya ibig sabihin, hindi na siya minor. Okay? Kung of age na siya, binenta sa'yo, okay lang yun. Kasi may consent. Valid yan. Kung asawa niya bumili, valid yan. Unless lang may mag-contest. Di ba? Kunwari, sabi mo, asawa ng guardian yung bumili. Kung walang nagkaso, is okay. Paano kung nagkaso yung relative ng minor? Di ba? Paano kung nagkaso yung kapatid niya or kung sino man na concerned dun sa minor na baka dahil sa guardian kaya naibenta sa spouse, di ba? That there could be undue influence. Or, since si guardian yung nag-administer ng property or nagmamanage ng property, pwede mong ipakita na there is undue influence kasi nga sa spouse binenta. Di ba? Pero if it is not questioned, it's okay. Pero you can question that. Actually, you can question that. Kasi that could be a sale, pero indirect sale. Hindi siya direct. Indirect meaning binenta sa iba, pero for the benefit of the guardian din. Pwede siyang i-question, actually. Pero kung hindi question, okay. It's okay. Okay, Miss Salva, I hope I answered your question.
Thank you po, attorney. Opo, clear na po.
Okay. Meron pa ba?
Wala na po, sir.
Okay, sige. That's all. Next meeting, okay? I hope I can help you.
Thank you po, sir.
Good night, everyone. Good night.
Good night po.
Thank you, sir.
Thank you po, sir.
Sir.
Thank you po, sir.
Thank you po, sir.
Sir.